Yes, sir. My name is Bill Kopsky. I'm Director of the Arkansas Public Policy Panel and Citizens First Congress. We represent over 50 organizational members and thousands of individual members throughout the state. I have a couple of observations on the testimony today that I can make in the next prepared remarks. The good news from you watching today, I think you have actually several easy fixes on your hands. I think the bill is not necessary. We wish it would go away. But if you're going to pass a bill, I believe you can change the security section so that only the security detail is exempt from FOI, and we get information on who else is on the plane. The governor's flight is for Sam Walton and the Tyson family or some other fat cats trying to make some deal. The public has a right to know that. I totally agree. We do not need to know who's in our security detail or any of that kind of information. It seems like a reasonable, easy fix that protects the governor's safety and gives the public access to the information they deserve to know on who else is on board. Something Force One, what would you call it? What would you call the plane? At any rate, who's on the plane with her? We have that right. The second thing that I think is easy is you can clean up the legal representation section that Senator Tucker was pointing out. There is a loophole there that is going to be giant in state government in the future. Maybe not this governor, because her attorneys have been said they won't do it. Someone else will. And I believe there's an easy technical fix to the language that Senator Tucker could give you. That just, if it's not your intent to drive a bus to it, then take Senator Tucker's suggestion to make that whole timing in. So it's just the purpose that you have. Seems like a super easy, reasonable fix that reasonable people could agree on. The third is the attorney fee section should just be eliminated, and I'll tell you why. Our organization represents a lot of low-income Arkansans, and we have had to repeatedly sue state government, local government, not sue, threaten to sue state government, local government officials to get access to files that were rightfully ours. And we use those files to do all kinds of cool things where we caught the state and local authorities not doing exactly what they needed to do. It is a key tool. But without that threat of us being able to sue, those folks would have ignored us. I guarantee it. And so that ability for low-income people to have legal representation to sue, to enforce the Freedom of Information Act is essential, and this bill curbs that dramatically. So those are my comments about the kind of reflecting today. I think you got some easy fixes on your hands. I still don't think the bill is necessary. Let me get into my other comments. So generally, we oppose this bill and do not believe the amendments made in redrafting the bill solve the inherent problems of expanding state secrets without extraordinary just cause. We also object to the chaotic and rushed manner in which this very serious topic is being considered. Many Arkansans, as you can tell, have passionate views on government transparency and state secrets, and this proposal should be considered in normal order in a normal legislative session to maximize public input so we can work together to resolve whatever just concerns this bill seeks to address. A rushed special session with normal rules suspended is not the time or the manner to address this respectfully. So when is the last time in your life that your life was made better by a politician or government official showing up and telling you they need to keep more things secret from you? I don't think it's ever happened. The Freedom of Information Act is the bedrock of democracy and one of the few areas where Arkansas leads the nation instead of lags. Democracy works because it's based on the people's power to monitor what their government is doing. It is all of our duty to ensure that government is always responsive and accessible to the people. At the panel on the CFC, we've used, as I mentioned, FOIA hundreds of times to uncover weak enforcement of health, economic, environmental protections, voting problems, all kinds of things. Happy to give you more details offline like those. We have used it on Republican officials, Democratic officials, nonpartisan officials. It is not a partisan tool to us. Many consider us to be a liberal-leaning organization, but I know many conservative-leaning organizations also use FOIA in their role as a government watchdog. It is essential for all of us. We all take care of our democracy by preserving and defending all of the mechanisms that allow us to be active and engaged citizens. It is the public's absolute right and duty to bring government officials back in line when they fail to do their jobs, when they act in bad faith, when they're corrupt, or when they abuse the power of their offices. Citizens and government are partners in the enterprise of creating healthy communities. That partnership only works when citizens have transparent information about government through the checks and balances of FOIA. FOIA not only exposes problems, it's also a powerful deterrent. To the specifics of the proposal, again, we think that the governor's staff, and frankly, or governor's staff, governor's family, and frankly, all state employees should be safe. This rush proposal goes far beyond safety, though. No one here has testified in favor of any of the other provisions of this bill. Not a single person. We've had a few witnesses say the safety stuff was important, and I respect that. There is a better way to do the safety things. If the governor needs more staff, more manpower, more resources to protect her family, she should get it right now. But this bill does not address her safety concerns. We need to have a normal process. You need to have a committee look at that. You already have a FOIA committee that you're ignoring. I just don't understand how this process is addressing the safety concerns that are totally legitimate. I'm a father of two. If I felt my kids were being threatened, you sure as hell right that I'd be up here demanding something happen. So I totally get that. The other changes in the bill, though, shrouding the cabinet officers who run nearly every state agency in secrecy when they talk with the governor, has nothing to do with security and is an unjustified power grab by the executive branch. Again, there's a way to fix the attorney-client privilege issue. I hope that you'll take that. But overall, this is just bad policy creating state secrets. Government officials, even when they're senior executive members, only hold the power of their positions because we, the people, have granted it to them. It's the whole key of principle of our democracy. We expect them to exercise their official duties in the public interest and in the public eye. We expect to be able to transparently monitor their work through Arkansas' strong FOIA. I'm going to close by asking you a political question. Those of you that vote for this legislation, how are you going to respond to your constituents when your primary opponent or your general opponent runs a mailer, a radio ad, saying that you supported a state secrets bill that removed their right to know what the government's doing, because you sure as heck can bet that those ads are coming to those of you that vote for this. No, I totally get you don't think the bill does that, but that's how it's going to be.
Thank you for that threat.
I am not threatening. That's not coming from me, sir. We are not going to do that.
Is there any questions?
That was not a threat, sir. Our organization will not do that, I promise you, but I also promise you that there are others that will.
Is there any questions from the members? Seeing none, thank you for your testimony.
Thank you all very much.
Julie McDonald. Introduce yourself, you're recognized.
Hi, my name is Julie McDonald. I'm from Faulkner County. I am with the Progressive Arkansas Women, and I'm from reading and all the rest of this today. I was here all day yesterday, like so many others. I had testimony prepared yesterday that focused on SB9. I'm pretty sure everyone else here has covered that and the changes that were updated to SB9. I would instead like to talk about the process of watching this unfold and how that affects this bill. I've been here and been involved since at least 2010, probably. I believe in government. I may be one of the few people in this room who's going to admit it. But even when I disagree with its actions, this institution, the Senate, the House, what happens in this building, it matters. It means something. Yesterday, a mockery was made of that. The reason that joke is widely known is because there's no one in the electorate who wants less transparency and accountability from government. But that's what you are proposing. You say this doesn't gut FOIA, and many governmental offices are excluded. However, just as it's been discussed, with the addition of a carbon copy on an email of an attorney or one of the offices that are now exempted from FOIA, then that communication is no longer FOIA-able. And therefore it's hidden from us, the citizens. Yesterday, when Senator Hester threatened to extract this bill, someone told the senator to pull the bill if he had the votes and deal with the consequences. So pass this here or extract it. Deal with the consequences of ignoring the will of virtually every Arkansan and really, in general, every American about accountability and responsibility in government. This issue, the possibility of changes to FOIA, has united all of the political spectrum by and large. There have been many Republicans here today. I'm from Progressive Arkansas Women, and we represent a broad swath of the political spectrum too. But you've united that political spectrum against such a measure, and for that, I applaud you. Like, good job. I did not know there was something that could unite us that way anymore. However, despite that worthy accomplishment, I ask that you vote against SB9 here and if it is extracted to the Senate floor. Thank you.
Thank you. Any questions? Appreciate your testimony. Josh Silverstein.
My name is Josh Silverstein, and I'm a law professor at the University of Arkansas, Little Rock, William H. Bowman School of Law. However, I'm testifying today in my individual capacity, not on behalf of the university. I want to also extend my thanks to Senator Johnson. I know this has been a difficult hearing to run. Like virtually everyone testifying today, I'm adamantly opposed to some of the changes in SB9, in particular the limitations on attorney's fees, which I believe will gut the Arkansas FOIA. I think Senator Johnson's been right to ask about how that will happen, and I'm going to try to elaborate on that. I also think the attorney-client privilege language needs much more careful drafting and will do serious damage. In order to save as much time as possible, I've tried to greatly pare down my remarks, and I want to note that I strongly endorse the testimony of several who have already testified, including Joy McCutcheon, Robert Steinbuck, Clint and Jennifer Lancaster, and Bill Kopsky. I think they all offered excellent talking points, and I also agree with the comments that Senator Tucker has made. I want to also address the important question that Senator Johnson raised earlier about the call of the session. When it comes to the call of the session, the legislature can't go beyond the call, they can go narrower than the call. So this bill could be greatly pared down. It would be consistent with the call of the session. It would not be out of order constitutionally. On the issue of attorney's fees, the reason that change is so problematic is it effectively applies to all records that are otherwise subject to FOIA. Attorneys generally get paid in three ways. They have clients with enough money to pay them by the hour, they get a contingency fee, or they get fees from the government pursuant to statute contingency fee when you're seeking money from someone. And these lawsuits aren't seeking money, they're seeking documents. In addition, as several attorneys have already noted, most people don't have the money to pay an attorney to engage in any type of FOIA lawsuit. So even in circumstances where the government clearly should turn the records over, so the case is clearly meritorious, there will be much litigation that will not be brought if attorney's fees are not available. And by changing the rules so that it's not enough to have substantially prevailed, you must also show arbitrariness or bad faith, and also changing the language from shall to may, that is going to greatly reduce people's ability to bring cases. Lawyers will just generally not take the cases. And we all know that litigation creates incentives, and without that incentive, government agencies, many times acting in good faith, will be much less likely to turn over records. I also want to talk a little bit about the attorney-client privilege. So, as Senator Tucker has identified, Section 30 is really not that bad. The problem is with Section 31. And I want to explain why that provision will create so much problem in the government context, though it doesn't in the normal civil context, as Senator Johnson noted. And that's this. The vast majority of things that private companies and private citizens do not concern whether they're obeying with the law or not. They're just simply engaged in their business. And so if a large company, like a former client of mine, say Dow Chemical, started copying their attorneys on everything they do, that would make the documents privileged. That's established. But almost everything that every government official does in doing their job is implementing the law. So when government officials start copying lawyers on their documents, they are plausibly seeking government advice. That's why the broad attorney-client privilege provision written here is going to shield so many documents, and why things like the Penn State example have been brought up. That's what makes the government different from the private sector in terms of the attorney-client privilege. I actually think there's room, and there should be some type of privilege in the context of litigation. But the way this provision is written, this carbon copy problem is a real one in ways that would not be in the private sector. I also want to address an important point that Senator Dotson raised, which is what about when it comes to criminal activity? So it's important to draw a distinction between past and ongoing criminal activity. If a murderer comes into my office and says, I just killed somebody, that is 100% covered by the attorney-client privilege. If someone comes into my office and says, I want your help killing someone, or I want your help engaging in some illegal scheme, that's where the crime fraud exception steps in, and the attorney-client privilege no longer applies. A lot of what happened in the Penn State context that some people have raised was past activity. And those documents weren't covered because of the, or weren't producible under FOIA because of the attorney-client privilege. Throughout the testimony,
One second, I got a question.
please.
Pennsylvania higher education is exempt from FOIA, is there at?
That is not my understanding, no. But Steinbuck would be the person to ask for sure on that. That is not my understanding. I'm not aware of any state in which higher ed, as a general rule, is exempt under FOIA.
So it was attorney-client privilege in Pennsylvania since this is the third time it's been read.
That is my understanding, that it was the attorney-client privilege that was the exemption that created the problem with the documents.
Thank you.
My pleasure. So there's been a number of specific examples brought up of things that we all realistically don't want disclosed. One of the examples was the Arkansas Razorbacks playbook, which, by the way, is already exempt under the competition privilege. So that would never be an issue. I think Senator Tucker phrased it best. When there's a particular problem, we want to draft a particular specific exemption. There's a disagreement about the precise scope of the exception for the security of the governor. I don't really have much of an opinion on that. I think it's reasonable. I think you can argue a little too broad, a little too narrow. But that's the type of exemption that should be drafted. If there's a concern about people asking for attorney's fees when they've lost, which I'm pretty certain has never happened, and I know no one's ever recovered when that happened, the answer is to add to the sanctions for frivolous lawsuits. Clint Lancaster already explained that Rule 11 would prevent or would lead to sanctions for anyone who makes a frivolous argument. But if you're worried that Rule 11 doesn't go far enough, pass a bill that says, if you ask for attorney's fees when you've lost, you are per se sanctioned. Frankly, I'm a law professor. I wouldn't have a problem if you said those lawyers should be disbarred for asking for fees when they've clearly lost the case. That's the type of specific exception that I think you want to put into place. I'm going to skip over most of the rest of that. And here's the only other thing I'll say. I've testified before this committee many times, and I've tried to avoid using sky is falling rhetoric because I just generally think it's ineffective and it's not true. I've used some of that rhetoric today because I think there's a really good argument that if this bill passes, the sky will have fallen when it comes to government transparency. I don't like to use the big rhetoric very often. I like to keep my powder dry when it matters. This is the time when I think it matters. I think this bill is extremely dangerous to government transparency, as a result to government accountability, and as a result to our democracy and our republic. And I take any questions that you might have, and thank you for letting me testify again.
So, Rule 11, second testimony. So, how many times has the court ever used Rule 11 and sanctioned lawyers?
It happens all of the time. It used to not happen very often, and then in 1993 they amended the rules of civil procedure to make it easier, and so lawyers get sanctioned all the time. It happened to multiple lawyers in the litigation over the 2020 election. Multiple lawyers were sanctioned, many were reported for ethics violations. So it is not the most effective tool in the world, and so if you want to add a little more protection, I would support that. But as a general rule, since the 1993 amendments, the federal rules that most states have adopted, Rule 11 is now a very effective tool and is regularly used to sanction lawyers for frivolous conduct.
We don't set those rules, correct?
No, but you can supplement them in the terms of the statutory context. You're right, the Supreme Court in most states sets the rules. But also in those states, the legislature has some authority to build on those rules in particular contexts. And so if you wanted to put in place additional sanctions, I think you could either do that yourself, especially in the context of FOIA. For example, you could write that sanctions are per se required in certain circumstances. It's like the inverse of attorney's fees, which you're allowed to do. And or you could ask the state Supreme Court to look at this and amend the rules if you think there's not enough. But I can tell you, Rule 11 is used all of the time in state and federal court. It's a very effective tool.